Yes, good afternoon. It's David Pryor. I'm a workplace relations specialist with Jobs Australia. Welcome this afternoon to our 2 o'clock webinar. And the topic today is, do I have to follow a lawful direction? So the subject matter is all about what happens in relation to lawful directions. Let me just say at the start, I'd like to do an acknowledgement of country. In the spirit of reconciliation, Jobs Australia acknowledges the Wurundjeri people as the traditional custodians of the land. We pay our respects to their elders past and present. So we might kick off now with the presentation. Next slide, please. So do I have to follow a lawful direction? Under the Fair Work Act and the regulations, an employee may be guilty of serious misconduct if they fail to follow out a lawful and reasonable instruction that is consistent with their contract of employment. In these circumstances, such a breach may result in disciplinary action and may ultimately end in dismissal, subject to the seriousness of the actions. The regulations are the only place where serious misconduct is defined, and that is Fair Work Regulation 1.07 in brackets 2, willful or deliberate behaviour by an employee that is inconsistent with the continuation of the contract of employment or conduct that causes serious or imminent risk either to the health and safety of a person or the reputation, viability or profitability of the employer's business. And it's deliberately in the regs so that if it's going to be amended, the Act does not require amendment and it doesn't go through Parliament and it does not get debated. So that is the background to where breaches of a lawful and reasonable direction may end up, particularly if it's something on the serious end of the scale. Next slide, please. So what is a lawful and reasonable direction? You won't find it mentioned anywhere in an Act because it's a common law prescription. That means under common law on decided cases, employees have an implicit duty of obedience and cooperation in their contract of employment. So as an employee, all employees have a duty of care to carry out lawful and reasonable instructions or directions from their employer. A lawful direction is one where the employer does not require the employee to contravene a Commonwealth, state or territory law. If such direction was given, it would not need to be complied with because whilst it might be reasonable, it simply in those circumstances would not be lawful. Next slide, please. So I put some cases in. So Powell versus Hunter Water Corporation back in 2012, the employee was summarily dismissed in those circumstances in that matter because they didn't follow a lawful and reasonable direction to take their car to be immediately serviced. The employee actually ignored the direction, went out and drove the car from job to job for the rest of the day. And as a result, he was invited to a meeting and it was determined that he could have complied. It was lawful and reasonable. It was important that the car be serviced. And by refusing to do that, he had breached the lawful and reasonable direction and it was deemed to be serious misconduct and his employment was terminated. This, of course, has gone to the Commission and that decision was upheld. The next one is Burns versus Sacred Heart Mission from 2014. In this particular instance, the employer terminated the employee's employment on the basis that they had engaged in serious misconduct by failing to attend a scheduled medical appointment without reasonable explanation. This comes up quite often in relation to independent medical exams with MLCOA or other providers. And it's a lawful and reasonable direction or an instruction in those circumstances in writing to an employee to attend that medical appointment, to answer the questions, to generate a report. And unless there's a reasonable explanation by not doing so, it's a breach of a lawful and reasonable direction. In this case, in addition, they had failed to comply to attend meetings on at least 3 occasions. This, of course, has gone to the Commission. And in the circumstances, the Commission has upheld the decision on the basis of the lawful and reasonable direction that was issued, that it was reasonable, it was lawful, it could be complied with, and the termination stood. So this gives you some example of how these types of cases play out in the Commission. So it's always important to consider what is being asked. Next slide, please. So the reasonableness of the direction will depend on the circumstances in each individual case. There's no prescription for this. The things that you as the employer need to consider would be whether the direction you intend to give is reasonable. What's the nature of the work that the employee is performing? Is there anything specific in their contract of employment that will impact on this? What are your historical customs and practices? And what's the ordinary course of dealing between the parties? In some workplaces, there may be more latitude in relation to such things as language on the loading dock, conversation in the lunchroom, and a range of types of things that may be different in different workplaces. It's very important to have consideration of these types of things before you're issuing or asking an employee to comply with a request. Because by making that request, it's underlined by the premise that if it's lawful and reasonable to comply with the request, the employee would be expected to do so. And should they fail to comply without an appropriate reason or excuse, it is likely to then be a breach of a reasonable direction. And depending on the seriousness of the circumstances and the thing which is the core, the reason for the lawful direction, if it falls into the ambit of serious misconduct, it may, in those circumstances, end up in a dismissal. Next slide, please. So an employee cannot be expected to follow an employer's reasonable direction simply if it's unlawful. It might be unreasonable. It may be outside their ability or their qualifications, or they might not have the equipment, or they might not be trained to use the equipment that is conditional upon the request to do something. To comply with such a direction would cause imminent or serious risk to the health and safety of an employee or other workers. It's one thing to walk past a PowerPoint and ignore, for example, that it's got 6 things plugged into it. That might be a workplace health and safety issue in itself, but it's inappropriate, for example, to ask an employee, for example, who's not an electrician, look, can you rewire that PowerPoint? It's sticking out of the wall. It needs to be fixed. Is it unlawful? Well, it may be lawful depending on the circumstances. If they're not an electrician, obviously it's unlawful, and clearly it's unreasonable. It's outside their qualifications, and it's likely to cause serious or imminent risk if the person's not appropriately qualified. So I'm just using a really simple, obvious example. It can be more convoluted in the workplace, depending on the circumstances and the types of work practices that prevail in the workplace where you are currently managing employees. So refusing to follow a lawful directive under these types of circumstances will not constitute serious misconduct, and therefore cannot result in summary dismissal or even circumstances which would lead to dismissal. Next slide, please. So examples of unreasonable refusal. So there are many ways an employee could unreasonably refuse an employer's reasonable direction. An employee may fail to perform their inherent role and responsibilities as stated in their contract. So it may be something in their contract or something in their PD that they have failed to perform, or that they have said, look, I'm just not going to do that. An employee refuses to comply with all or part of a company policy or procedure. Well, it's the code of conduct. I know it says what it says, but I actually disagree with that section on page 4. So I'm just using some examples where somebody may take you to task about a current policy or procedure that's in place, or they may have an issue with something in their position description, for example, all of which promote having a robust discussion with the person. However, in those circumstances, if it's in a PD or if it's in a company policy or procedure, you have a reasonable expectation that they will comply with the requirements of the document in terms of what it set out and what it proposes. An employee that deliberately ignores or refuses to comply with their supervisor's instruction, an employer introduces significant change to the workplace and employees refuse to accept the change. oh, look, I've read the change management plan. I know you're looking at perhaps making my role redundant. I'm not interested. I don't want to participate. Unfortunately, in those circumstances, that would not be a reasonable response. And there is an expectation that unless there is a reasonable excuse, an employee will be able to comply with the lawful direction, provided it's reasonable and it's lawful. And workplace change in a consultation period certainly is a clear example of an interaction and a process where the expectations in terms of consultation and participation clearly would be reasonable and clearly in normal circumstances would be lawful. And the one I touched on before in one of the cases, an employee refuses to participate in an independent medical examination where it's reasonable to do so. I don't want to go for the examination. I don't think I need it. Unfortunately, if that was an answer, that is not an appropriate response. And the expectation is that they will comply and it's reasonable, and in those circumstances, it's lawful. And lastly, employees continue to act in a manner which is unreasonable in circumstances dealing with things like presentment, which is another way of saying absenteeism, punctuality, or lateness. There's a pattern of behaviour. You've been late 6 times in the last 3 weeks, more than 15 minutes. I've met with you on 3 occasions. I'd like to talk to you about how we can improve your punctuality. So in circumstances where a person has continued to present the pattern of behaviour, it may be construed that that's being unreasonable in terms of being given directions about your expectations as the employer about their capacity to be at work on time, for example. Next slide, please. So it's recommended that for employers to make sure that when such behaviour is being dealt with, to do it quickly and efficiently, so that employees are informed about the seriousness and possible consequences of the type of behaviour that they've engaged in. If you don't act swiftly, you can create the false impression that as the employer, you actually condone this particular behaviour, and it's therefore an acceptable practice in the workplace. Well, why is it an issue for me doing this when other people are doing it all the time? The most important thing is to be efficient in terms of if the matter's been brought to you, to address it as soon as is reasonably practical. This otherwise can create a significant problem should they dismiss an employee for serious misconduct and the employee lodges an unfair dismissal application. If the employee can argue successfully that their conduct was accepted practice in the workplace, then the employer may experience difficulty in defending such a claim. On that basis, it's important where there's behaviour that's inappropriate, unprofessional, in terms of how somebody's conducted themselves. The important element is to be efficient in terms of, in a timely fashion, meeting with your employee to have them respond to allegations or concerns in relation to the type of behaviour that's being exhibited or the type of work practice that they're engaging in, so they have an opportunity to explain what's occurred, and there may be a reasonable explanation for what they've done. The important thing is not to let it drag on before you have the opportunity to have that first discussion about what has occurred in terms of why it's a concern, and have them respond to your concerns in those circumstances. Next slide, please. So the important thing is to conduct an investigation. So although serious misconduct may, for example, justify summary dismissal, the employer must go through an appropriate process with steps to investigate whether there are valid reasons for an employee's refusal to comply with an instruction before engaging in disciplinary action. So they don't get a letter of warning straight up. You don't bail them up in the corridor and say, look, you know, what you did on Friday was inappropriate. You know, I really don't want you to do it again. What do you have to say? The appropriate thing is to set a date and time, meet with them. If it's going to be formal, it needs to be in writing. Give them at least 24 hours notice, allow them the opportunity to bring a support person. And refusal may be due to concerns about safety. They may have seen something which they believe is unsafe. There may be a personality clash between themselves and another employee, or perhaps them and their particular supervisor. In rarer circumstances, industrial action may be occurring, which is only lawful if it's during a bargaining period and the appropriate notices have been given, or there may be a lack of training in the work to be performed. An employee may be reluctant, uncertain, uncomfortable in relation to doing a particular type of work or working on a particular machine, for example, and it's reasonable for them to raise their hand and say, look, I haven't had training or refresher training in that for 5 years. Can you help me? That's why it's important to put to them your concerns and give them an opportunity to respond before making any decision about what the nature of the event is and whether there's a reasonable explanation as to why the employee has not complied. So understanding why the employee has refused will assist in overcoming the issues or making adjustments that in normal circumstances will satisfy both parties. Next slide, please. So part 2 of conducting an investigation, undue delay by an employer to investigate any serious act by an employee may be viewed as an industrial tribunal as actually condoning the behaviour. Well, Mr. Employer, this went on for 6 weeks. If it was serious, why did you not address that the second time it was brought to your attention? So the important thing is to be timely. If the behaviour is continually repeated or sufficiently serious, termination of employment may be considered. We've had a look at what the definition of serious misconduct is. Before you necessarily arrive at that conclusion, it would depend on the individual circumstances, what the particular event or thing is that the employee has been asked to do, perform, or participate in, and the opportunity to meet with them and have them explain in their own terms why, or if there's any reason or explanation as to why they elected or did not comply with the reasonable direction before making a decision about what would be an appropriate outcome. Next slide, please. So what are the next steps? Once it's established that an employee has engaged in serious misconduct, as I mentioned earlier, there are important steps for the employer to undertake before termination of employment may occur. Next slide, please. So the process involves discrete steps. Arrange a meeting with the employee to discuss the conduct. Advise the employee that they can have a support person of their choosing to attend the meeting if they wish. Provide them in advance of the meeting with a letter outlining your allegations about the alleged misconduct. This letter, if this is serious misconduct, will state that the employee faces disciplinary action up to including termination of employment where the allegations are substantiated following an investigation. This lets your employee know in no uncertain terms that the allegations are serious and the consequences may also be serious, subject to you not having or not making any final decision until you've given consideration to their responses. At the meeting, the employee must be allowed to respond. This is the central pivot of this process, to put the issue to the employee, to have them respond, and then for you to consider their response. So the employer may reach the conclusion that the employee has engaged in serious misconduct, and the employee may be terminated with or without notice, again, depending on the seriousness of whatever the breach or the event is that has brought about the alleged serious misconduct. The outcome letter will then set out the reasons for termination, if in fact that is the outcome, to be provided to the employee, including whether paid notice is being provided or not. If it's summary dismissal for serious misconduct, it is normal and quite usual for there not to be notice paid in those circumstances. Next slide, please. So we've kind of ripped through this fairly quickly today, but I've got some additional material that I would like to discuss in terms of a legal case that came forward on the 9th of August with SPC. So what I might do is go through that now before we go through the conclusion. So SPC as an employer that has had the first legal test case for employee mandated COVID-19 vaccinations. So they enforced a 6-week period in which employees can book their first vaccination to avoid running the risk of being barred from on-site work. They've allowed for days of personal leave if an employee became unwell after receiving the vaccine. And also another problem posed by their direction was how the employer would deal with visitors on site and manage their vaccination status. Interestingly enough, SPC did not base their mandate on a public health order or a chief health officer's order. They based it on the company's workplace health and safety obligations and status as an essential service. So they've done a risk assessment. They've determined that the Delta strain is very virulent and it's likely that people can be seriously injured and may also die. And in those circumstances, as an employer, they've made a decision that it's an acceptable risk to put forward a policy to mandate that if you're not vaccinated, you cannot present for work. Staff threatened to leave the company due to the lost autonomy, and it went to court. In light of the direction, food manufacturers and the council called on the government to clarify the legality of policies which mandate a vaccine. And the Fair Work Ombudsman's current stance is for employers to assume that they can't require their employees to be vaccinated against COVID. However, the Ombudsman is now reconsidering this further and will probably provide further guidance in terms of more information on their website. The takeaway from this is simply that the important thing to remember is if, for example, you are mandating vaccines in the workplace, you must give people an appropriate time to be vaccinated, an appropriate time to come forward with medical exemptions, and particularly if they're over 60, as I understand it, if their particular vaccination is not available, they would need to present with some form of written evidence from their treating practitioner about what vaccine may be available and when they're able to book that. Now that we're past the October 25 deadline, in Victoria, for example, and different, obviously, in other states and territories, it's pretty important that under the mandate that's been issued for the public health orders in terms of essential workers and workplaces where all employees of the organisation must be vaccinated, that this case has indicated in clear terms what is defensible in terms of what can be mandated from the basis that they have gone with a risk assessment on their occupational health and safety obligations as the basis for their policy. And of course, the interesting thing is that so far there have not been any dismissals. So the moot question as to whether COVID-19 vaccination failure to be vaccinated is a valid reason for termination has to date not been tested. So coming back to the conclusion, so following these steps outlined above in relation to ensuring that you meet with the employee, put the concerns to them in writing if it's serious, give them an opportunity to respond, have their support person present, you go away, you consider their response, and then you come back and communicate an outcome. We'll provide you as an employer with the best defence against any possible unfair dismissal application lodged by a former employee after termination. If you're going into one of these meetings with your employee, you are welcome to come forward and touch base with the industrial advisors at Jobs Australia. We're happy to talk to employers before they conduct a meeting, happy to bug test, reality test, what your steps are, what your process is. It's always easier to talk about something before it's happened than talk about what I did yesterday. So we certainly recommend that if you're wanting to speak to us about these types of matters before conducting the meetings, that's what we're there for, and we're happy to assist and provide any guidance and support in relation to the process that you're about to embark on. It's also recommended that you as the employer have a note taker present so that that person can take notes so that you can have eye contact, or if we're in Zoom or Microsoft Teams, you may want to take notes, or you may have a third person in the meeting from another laptop, obviously making notes so that, again, you can concentrate on speaking to the employee. Lastly, and if in any doubt, it's always good practice to obtain advice about how to proceed with the matter involving the employee before meeting and discussing with your employee. That's what we're here for. We're here to assist and provide guidance and support if you wish to do that before conducting meetings with your employees. Next slide, please. So what I would like to say is, on behalf of Jobs Australia, to those employees who are attending today, thank you for your attendance. And I hope that in terms of going through the elements of what's in a lawful and reasonable direction, that this has helped and assisted you to understand, perhaps in clearer or perhaps a little deeper terms, what's actually involved. It's a term that's commonly bandied around. People talk about lawful directions, and it's interesting to delve into it, to look at the decided cases and to see what underlines it, that in fact, it's not a question of when people come back to me and say, David, where is it in the Fair Work Act? Well, it's not. It's common law. It's based on judge-made law, which is decided cases. So at common law, it's a test to determine what's reasonable and to look at what's lawful in relation to the individual circumstances of your employee in the workplace, what you're asking them to do, and whether, as in some examples, it is reasonable for them to refuse. It is reasonable for them to say, look, I can't comply. Not every lawful and reasonable request, in fact, will be, when it's taken apart and broken down to the base elements, satisfy an objective assessment at a later date under scrutiny that perhaps it was reasonable, but it might have not been lawful. Or perhaps it was lawful, but there was an element of it that was unreasonable. Again, I must say, on behalf of Jobs Australia, thank you everybody for attending. And this is an opportunity that if anyone has any questions, raise your hand or put those questions up, and Britt will be able to put them to me and we can provide some answers if anyone has any questions about today's session.
Thanks, David. There's no questions coming through, so you might have answered everybody's questions. But as David mentioned, if you do require any further information, the team is always available for you. I'll just move over to that last slide. The contact details are there, so there's the email address or the phone number. We will also send this recording out to you this afternoon, so you'll receive that via email as well. So we might close off this session. So thanks, David, and thanks everyone for attending, and enjoy the rest of your afternoon.